Welcome back, everyone. Today we're taking a deep dive into UK criminal law.
Ooh, exciting.
Yeah, and to guide us, we have this excerpt from Introduction to UKcriminallaw.pdf.
Sounds good to me.
So, we often talk about criminal this and that, but
Yeah.
what really makes criminal law stand out from other areas of law?
Well, that's where things get interesting.
Okay,
It's not simply about, what's right or wrong.
right.
Criminal law steps in when actions are so serious, so harmful to society,
Yeah.
that demands the state's attention.
Mm.
It's not just about, individuals settling personal disputes.
So it's not just your neighbor blasting music late at night.
Exactly.
We're talking bigger, right? Offenses that kind of shake the whole foundation of our societal order.
Precisely. And to really illustrate this, let's look at a case mentioned in our source material,
Okay.
the case of Ireland.
Ireland.
Yeah, this one's a real head-scratcher. It challenges our perceptions of what a crime actually is.
Okay, I'm intrigued. What happened?
So in this case, you had a man harassing a woman with constant silent phone calls.
Silent phone call.
Yeah, really unsettling stuff. And it caused her severe psychological distress, to the point of a breakdown.
Oh, wow.
And get this, he was convicted of assault occasioning actual bodily harm.
Hold on. So wait, just silent phone calls and he was convicted of assault.
Yeah, makes you
Ew.
think, right? Can psychological harm really be considered bodily harm under the law?
Right, because he wasn't physically touching her.
Exactly. No physical contact.
Yeah.
So where's the assault?
And when we think bodily harm, we usually picture like bruises, cuts, that kind of thing.
Exactly.
Not just, being scared or stressed.
Right, but this is where it gets interesting. The House of Lords actually upheld the conviction.
Really?
Yeah, setting a precedent that severe psychological harm can be considered actual bodily harm under UK law.
Wow. So it's not always black and white, huh? What feels morally wrong and what's legally a crime, I mean?
Absolutely. And this leads us to a bigger question. What's the fundamental purpose of criminal law in the first place? What's it trying to achieve?
It can't just be about punishing people.
Right.
There's got to be a deeper goal, right?
Exactly. Our source actually points to the American Model Penal Code,
Okay.
which lays out 5 main purposes of criminal law.
5. Okay, let's hear them.
So, first and foremost, it's about preventing harmful conduct, deterring individuals from actions that could hurt others or disrupt, the social fabric.
Okay, that makes sense. If people know certain actions will get them in trouble, they're less likely to do them. What else?
The second purpose is about controlling those individuals who are prone to committing crimes.
Okay.
Think probation, rehab programs, sometimes even imprisonment. It's about preventing future offenses.
So there's a proactive element there, trying to break the cycle of criminal behavior, not just reacting to it after it happens.
Precisely. It's not just about punishing the past, but also protecting the future. And third, it's about protecting innocent people from being unjustly punished. Upholding that innocent until proven guilty principle.
Right. Due process, the cornerstone of a fair legal system. We can't just go around accusing people without evidence and a fair trial.
Exactly. What are your thoughts on the last 2?
Hit me.
Number 4 is all about giving clear warnings as to what actually makes something a crime. The law should be, accessible and clear to the average person so that people know the boundaries.
Makes sense. Got to know the rules of the game.
Exactly. And lastly, it's about differentiating between how serious different offenses are. Not all crimes are created equal.
Absolutely not.
A parking ticket shouldn't carry the same weight as, say, assault.
Right. Totally different levels of severity.
Right.
So we've got the goals, the why behind criminal law, but who are the key players making this whole system work?
Well, the first line, so to speak, is our law enforcement agencies,
Yeah.
the police.
Right. They're the ones investigating potential crimes, gathering evidence, apprehending suspects.
Exactly. But they don't get to decide if someone is actually charged with a crime.
They don't?
Nope. That decision goes to the Crown Prosecution Service, the CPS.
So they're like the filter, deciding if there's enough evidence to move forward with a trial. Do they always go for the most serious charge possible, or can they, be a little more strategic?
Oh, that's a good point. There's a tactic called undercharging, where the CPS might charge someone with a lesser offense than what they seemingly did.
Wait, really? Why would they do that?
It might seem counterintuitive. Our source gives some examples, like a robbery being charged as theft or wounding as assault.
Huh. Well, those are definitely less serious.
Right.
Is it easier to get a conviction that way?
That's one factor.
Huh.
It can also encourage a guilty plea, which saves time and resources on a big trial. Plus, A lesser charge might allow the case to be heard in magistrate's court, which is a quicker, less formal setting than Crown Court with a judge and jury.
Ah, so it's about balancing justice with the practicality of the legal system itself. Speaking of courts, magistrates, Crown Court, you mentioned different courts. How are offenses actually tried in the UK? Is it always a jury trial like we see on TV?
Not quite. We have three main ways: summarily, on indictment, and either way. Summary trials are for less serious offenses handled by the magistrate's court.
Okay, no dramatic jury deliberations for those. What about on indictment?
That's the big leagues. Crown Court. Judge, jury, the whole shebang.
Those are for the more serious crimes then.
Right. Murder, complex fraud, anything with a heavier potential sentence.
Makes sense. And either way, offenses. What's that about?
That's where the defendant gets to choose.
Choose what?
Magistrate's court or jury trial at Crown Court.
Huh. So there's some flexibility in the system. Wouldn't most people want a jury trial, though? Seems like a safer bet. 12 people deciding your fate instead of just one magistrate.
You'd think so, but actually most offenses are handled in magistrate's court. Yeah, it's quicker, less formal, less intimidating for everyone.
Huh, interesting. Okay, so we've got the big picture, the purpose, the players, the different courts. But let's zoom in on the heart of it. What actually makes something a crime in the eyes of the law? How do we determine if someone's actions are truly criminal?
Our source uses this great analogy, a recipe. Just like a cake needs certain ingredients to turn out right, a crime needs certain elements to be present to make someone criminally liable.
Okay, I like where this is going. So what are the crucial ingredients in this legal recipe for a crime?
Two main ones: actus reus and mens rea.
Actus reus and mens rea.
Yep. Actus reus refers to the prohibited conduct, the actual act or omission that the law forbids.
So that's like physically hurting someone, stealing, vandalism, the actual doing of something bad.
Exactly. But get this, having actus reus alone isn't enough.
Really?
You also need the mens rea, the mental element.
Okay, so the intent behind the action.
You got it. Did they do it on purpose? Was it an accident? It's about the defendant's state of mind.
Our source uses the example of murder to illustrate this. Can you break that down for us?
Sure. So the actus reus of murder is unlawful killing. Straightforward enough. But for a murder conviction, they also need to prove mens rea. In this case, it's called malice aforethought.
Malice aforethought. That sounds intense. What does that actually mean in simpler terms?
Basically, it means the killing was intentional. They meant to kill or to cause serious harm. Without that intent, it might be manslaughter, which has a different mens rea.
So we've got the act itself, actus reus, and the guilty mind, mens rea, the two big pieces of the puzzle.
Right.
But our source mentions a third element too.
Ah, yes. The absence of a valid defense.
Okay.
Even if someone did the crime with the right mental state, they might still get off if they have a legally recognized defense.
Like self-defense.
Exactly. If you're being attacked, you have the right to defend yourself, even with force.
Makes sense. So you're saying all three of these have to be there for a conviction.
You got it. But hold on. Let's say all those elements seem present. Who has to prove what in court? Does the defendant have to prove they're innocent? Ah, good question. That gets to the heart of our justice system. In criminal law, the burden of proof is on the prosecution.
Okay.
They have to prove every element of the offense beyond a reasonable doubt.
Beyond a reasonable doubt, that's a pretty high bar, isn't it?
It is. It's not about just convincing the jury that the defendant probably did it.
Right.
It has to be near certainty. Even a tiny doubt can lead to an acquittal.
So the prosecution's got their work cut out for them. Our source brings up an example of someone claiming a shooting was an accident. How does that burden of proof work there?
Well, even if everything points to the defendant pulling the trigger, if they say it was an accident, the prosecution still has to prove intent.
So they can't just say, well, looks bad for you, so you're guilty.
Exactly. They have to show the defendant acted with the necessary mens rea in that case, intentionally causing harm.
So even in what seems like a clear-cut case, proving that mental state is essential. And this burden of proof applies to both actus reus and mens rea, right? They got to prove the action and the intent.
Absolutely. That's the weight they carry throughout the whole trial.
Okay, lots on the prosecution's shoulders. But what about the defense? Do they just sit back and watch, or do they have any burden of proof too?
They do, but it's a different kind. It's called the evidential burden.
Wait, hold on. Evidential burden.
Yeah.
What's the difference between that and the burden of proof we've been talking about?
Well, the evidential burden kicks in when the defense wants to raise a defense.
Okay.
Like self-defense, duress, Insanity. They don't have to prove it beyond a reasonable doubt, but they have to show some evidence to back up their claim.
So if they're saying self-defense, they need more than just their word.
Exactly. They need to give the court something solid. Witness statements, medical records, anything to support their claim that they were genuinely in danger.
So once they do that, what happens?
Then the burden shifts back to the prosecution to disprove the defense beyond a reasonable doubt.
So it's a back and forth then. A legal tug of war.
That's a great way to put it. And that tension is what makes our criminal justice system work. It's all about fairness and balance in pursuit of truth and justice.
Wow, this has been a great start to our deep dive. We've covered the purpose of criminal law, the key players, that crucial recipe for a crime, even this concept of burden of proof.
Yeah, we've laid the groundwork.
But there's so much more to uncover.
Oh, absolutely. Join us for part 2, where we'll dive deeper into Actus Reus, mens rea, and those fascinating defenses that can make or break a case. We'll also explore how a trial actually works in the courtroom.
Stay tuned, folks. It's going to get even more interesting. Okay, we're back, ready to go even deeper into UK criminal law. Last time we talked about the purpose, the players, those essential elements of a crime, actus reus and mens rea.
And who could forget the absence of a defense? That third piece of the puzzle that can really shake things up.
Right, that's important. So let's unpack actus reus a bit more. You said it's the prohibited conduct, but it's not always as simple as just doing something, right?
You're right. It can be a bit more complex than that. Actus reus can show up in different ways. Sometimes it's about a specific action, like, physically attacking someone, or in theft cases, taking someone's stuff without their consent.
Right.
But sometimes it's about a certain result, a consequence that happens because of the action.
Can you give an example? I'm not quite picturing that.
Okay. Imagine someone takes a hammer to a window. The actus reus of criminal damage isn't just swinging the hammer. It's the damage to the window because of that swing.
So no broken window, no crime.
Well, in that case, no criminal damage, even if they meant to break it. The consequence is key.
Interesting. Are there any other ways actus reus can be, tricky?
Oh, absolutely. Sometimes it's all about the circumstances.
Circumstances.
Yeah, like the specifics of the situation that make an otherwise legal act illegal.
Okay, I'm following. Give me an example.
Say you're out riding a bike. Total legal, right?
No, of course. Nothing wrong with a bike ride. Where are you going with this?
But what if that bike you're riding was stolen? The act of riding the bike is fine, but because it's stolen, that changes everything.
So the context matters. The same action can be totally different depending on the circumstances.
You got it.
This is reminding me of that Ireland case we talked about earlier.
Yeah.
Was the actus reus of assault really there? He wasn't physically touching the victim, so...
That's the big question, right?
Yeah.
The courts had to figure out if fear of immediate violence, even without physical contact, could be enough for actus reus in harassment cases like that.
And they decided that, the psychological impact, that fear from the silent phone calls, it was enough.
It really pushed the boundaries of what harm can mean in the legal sense.
That's pretty significant. Actus reus is way more nuanced than I thought.
It's a lot to unpack for sure.
Okay, so let's move on to mens rea, the mental element. Can you kind of break down the different types of mens rea, the different, flavors of guilty mind?
Of course. Our source lays out several key forms: intention, recklessness, dishonesty, knowledge, and belief. They all center around a conscious decision to go against the law.
So it's about knowing you're crossing the line, not just stumbling over it by accident.
That's a great way to put it. Like, say you borrow a friend's fancy headphones without asking,
Okay.
intending to return them later, but you trip and they break. That's not theft. You didn't mean to keep them. But if you sold them knowing they weren't yours, well, that's dishonesty. That's a key part of theft.
So it's about what's going on in your head.
Exactly.
A thought process, that choice to break the rules. But are all crimes about this guilty mind, this intent to do wrong? What about accidents?
Good point. That brings us to strict liability offenses.
Okay.
These are offenses where you're guilty even if you didn't have any criminal intent at all. Like, think about speeding tickets.
Right. You don't have to be trying to break the speed limit to get a ticket.
Exactly. It's about keeping roads safe, not punishing people for being evil speed demons or anything.
So in some cases, it's not about the intent.
Right. Our source also mentions careless driving and gross negligent manslaughter. In these cases, it's more about a major lapse in judgment or a failure to act responsibly.
So even without meaning to do harm, you can still be held accountable if you're not careful enough. It's about taking responsibility for your actions, even if there wasn't, like, bad intent.
Precisely. It's a balance between individual freedom and protecting everyone.
That makes sense. Okay, I think we have a good handle on Actus Reus and mens rea now, but what about those get out of jail free cards? The defenses.
Ah, yes, the defenses. They make criminal law so much more interesting. Our source mentions self-defense, insanity, consent, duress, and necessity as key defenses.
So many. Can you give us some real-life examples of how these work?
Of course. What's really cool is that defenses actually fall into two main groups: justifications and excuses. Let's start with justifications.
Okay, justifications. What makes those different from excuses?
A justification means the act itself, even though it fits the legal definition of a crime, wasn't wrong in that particular situation. Self-defense is the classic example.
So if someone breaks into your house and you fight back to protect yourself and your family, you're not really doing anything wrong because you're, well, trying to survive.
Exactly. The law says you have the right to defend yourself from harm. But of course, there are limits.
Right, it has to be proportionate to the threat. You can't just, like, go crazy and call it self-defense. What about excuses, then? How are those different?
Excuses acknowledge that the act was wrong, but argue that the person shouldn't be fully blamed because they weren't in control of their actions. Duress is a good example here.
Duress, so like being forced to do something.
Right. Say someone's threatening to hurt your family if you don't rob a bank.
That's awful.
Right. The law might excuse your actions, even though robbing a bank is obviously wrong because you were under extreme pressure.
So even if you did the crime, you can argue you didn't really have a choice. What are some other examples of excuses?
Insanity is another big one.
Okay.
The defense might argue the person had a mental disorder that kept them from understanding what they were doing. They couldn't tell right from wrong.
That's got to be hard to prove, though.
It is. There are strict legal tests for that.
All right, so we've got justifications, where the act is okay because of the situation, and excuses, where the person isn't totally at fault. But how does a defense actually work in court? Does the person just say, I was under duress, and that's it?
Not quite. Remember that evidential burden we talked about?
Oh, remind me.
The defendant needs to give some real evidence to support your defense.
So more than just words.
Exactly. If they're claiming duress, they might need threatening messages, witness statements, something to show they were truly under threat. They have to convince the court that it's a real defense.
And then if they do that...
And then the prosecution has to try to disprove it. They have to show the jury that the defense doesn't hold up.
So it's back and forth again, this legal battle. This is making me realize how much strategy goes into a trial.
It really is like a chess match. Knowing how actus reus, mens rea, the burden of proof, and defenses work, it's crucial for anyone involved with the legal system.
Definitely. Knowledge is power. Okay, we've covered a lot of ground, but there's one last piece of the puzzle. The trial itself. How does a case actually move through the system? What do the judge and jury do? What happens in the courtroom?
All great questions. We'll dive into all of that in part 3 of our UK criminal law deep dives.
And we're back for the final part of our UK criminal law deep dive. We've talked about the basics, the key players, and all those legal ingredients that make up a crime.
Right, all the building blocks.
But now we're going right into the courtroom, the action.
Exactly. Time to see it all play out in a real trial.
So we've got our suspect. The Crown Prosecution Service has decided to go ahead with charges. What happens next? Give us the play-by-play.
Well, the case goes to trial, and this is where it can get really interesting.
Yeah.
Our source gives us a glimpse into how trials work in the UK, highlighting the roles of the judge, the jury, the prosecution, and the defense.
Okay, so paint us a picture. We're in the courtroom, maybe one of those old ones, all wood and grandeur.
Yeah, I love those.
Who are the main characters in this legal drama?
Well, first you've got the judge. They're like the referee, making sure everything follows the rules, the law, all that.
Okay.
They decide what evidence is allowed, they guide the jury on legal matters, and if the defendant's found guilty, they decide the sentence.
So they're the authority on the legal side. What about the jury then? What's their job?
The jury. They're the fact finders.
Okay.
They listen to all the evidence, both sides, witness statements, forensic stuff, everything. And then they decide the big question. Guilty or not guilty?
Wow, that's a huge responsibility.
It really is.
They're deciding someone's fate.
And they take it very seriously. They have to weigh the evidence, consider both sides' arguments, follow the judge's instructions on the law. It's not about personal feelings. It's about applying the law to the facts.
Right, it's a system. Our source talks about the Ireland case again here.
Right.
What can you tell us about how that played out in court, specifically the judge and jury's roles?
Well, a big issue in that case was whether causing psychological harm could really be considered actual bodily harm under the law.
Right, because that's what made the case so unique. It challenged our understanding of what harm really means.
Exactly. The defense lawyer, he argued against it, but the judge ultimately ruled that, yes, it was covered by the law.
So the judge is the one who interprets the law.
Right. Clarifies what it means, sets those boundaries for the jury to work within.
Okay, so the judge is the legal expert, keeping everything running according to the law, and the jury works within that to decide the facts and reach a verdict.
That's it.
Got it. In the Ireland case, because the judge ruled that way, the defendant ended up pleading guilty, so the jury didn't actually get to deliberate.
Right. But in many cases, it does go to the jury for that final decision.
Okay, so the rules are clear. But how does it all actually happen? What's the step-by-step? What are the big moments in a trial?
It's all structured to make sure it's fair, that all the evidence is looked at properly. Both the prosecution and the defense, they get to present their cases. They call witnesses, they show evidence, they make arguments, trying to convince the jury of their side of the story.
It's like a battle, then, to win the jury over. Must be intense.
It can be. And remember, the prosecution has the burden of proof.
Right.
They have to prove beyond a reasonable doubt that the defendant is guilty.
That standard is tough.
Right.
What happens after both sides have made their case? What happens next?
Then it's the judge's turn again.
Okay.
They sum up all the evidence for the jury, explaining the law, highlighting what's been disputed, reminding them to be fair and impartial.
So they kind of tie it all together, give the jury a roadmap before they make their decision.
Exactly. These are called jury directions, and they're really important. The judge has to be very careful, unbiased,
Right.
making sure the jury gets it. If they mess this up, it can be grounds for an appeal.
High stakes. The judge is important, but ultimately it's up to the jury.
That's right. They go off, deliberate in secret, discuss everything, try to reach a decision. And in the UK, the verdict has to be unanimous.
Unanimous, wow. So all 12 have to agree.
Yep, everyone has to be on the same page.
What happens if they can't agree?
That's a hung jury. Tricky situation.
Yeah.
The case might be dismissed, or they might retry it with a new jury.
So after all that, the jury comes back with their decision. Guilty or not guilty. What then?
Well, if it's not guilty, the defendant is acquitted, free to go, case closed. But if it's guilty, then the judge decides the sentence.
And that's another whole area, right? Sentencing.
It is. It depends on the crime, the person's history, all sorts of factors.
This has been an incredible deep dive. We've learned about the foundation of criminal law, the courtroom drama, the roles of everyone involved, all the intricacies of evidence, defenses, the jury's responsibility. It's a lot to take in.
It really is. But I hope our listeners have a much better understanding of how the UK criminal justice system works now.
That's what we're here for, to explore, learn, think critically about the world. And speaking of thinking critically, it leaves me with a question. If criminal law is meant to reflect our values, protect us, uphold justice, does it always do that? Do our laws always match up perfectly with what we think is right and wrong?
That's the question, isn't it? Think back to that Ireland case. Did the law get it right there? Was justice served? Something to keep thinking about.
Exactly. Laws change, they reflect our society, and it's up to all of us to engage with them, challenge them, make sure they're doing what they're supposed to. Thanks for joining us on this deep dive into the fascinating world of UK criminal law.